welcome to Legally Speaking with me, Tarun Nangia. Today's interview is on the law of sedition and its relevance in the present context of today's India of 2021. Is it necessary? Should it be amended? What should be done with the law? Does it need more public discourse and discussion? The kind of convictions or the percentage of convictions that have been happening when people are booked under this law, all of these things will be discussed today. We have an eminent guest, senior advocate Siddharth Luthra. As we all know, he has served as the Additional Solicitor General of India. Mr. Luthra, welcome on Legally Speaking with Tarun Nangia.
Thank you, Tarun.
Well, at the outset, law of sedition and your views, in a sense, is not new. Your views are well known. You have expressed them earlier. In 2021, and then examining the kind of cases that you've been seeing that people have been booked under in law of sedition, what would you recommend? An amendment to the law, or you think we should do away with it?
So, Tarun, I must tell you, I have two sets of experiences with this law. One, I'm a prosecutor in a matter where somebody is charged with sedition, and therefore that is one part of my professional engagement. But speaking as a student of the law, my view is that is sedition relevant in a democratic republic? That's a fundamental question we need to ask. In a kingdom, in an empire, yes, you may talk about the relevance of sedition. But in a nation like India, which swears by free speech, where the right to express yourself is a constitutional right, subject to reasonable restrictions, but a fundamental right. Can we really consider sedition in its forms? In fact, it's surprising that the law continued. There was a constitutional amendment. And despite the fact that it should not have, according to me, existed beyond the constitutions being brought into force, yet sedition was not only accepted, but the classic decision of 1962, Kedarnath Singh's case, interprets it in a very, very restrictive manner. The whole idea was the application of sedition should be limited. But practically speaking, look at the numbers we're dealing with. The sheer application of sedition in one of the problematic areas that you see is that every time somebody is saying something offensive against a government functionary, maybe even a constitutional functionary. So a few years ago, there's a magazine called Nakiran. There's a gentleman called Gopal. He was prosecuted for saying something against the governor of Tamil Nadu. Now, it may be offensive, it may be defamatory, but merely because individuals believe or governments believe that defamation does not have teeth or the teeth that they desire, should recourse be taken to stringent provisions such as sedition. And this has been happening across the board. When sedition is applied, chanting of slogans, inappropriate slogans, anti-national slogans, protesting, expressing your right to your understanding of how the republic should be, cannot be a basis to lock people up or prosecute them. Why is it that in 2018, you have 1,012 cases registered against, and I'll tell you the categories: Northeastern insurgents, jihadi terrorists, Naxalites and other terrorists, or students who have a different view. You take people into custody. Way back in 95, 97, the law was settled. It was a distillation from Kedarnath Singh's case that the mere raising of slogans, whether it be on the issue of Punjab or Kashmir or otherwise, cannot be an offense. Today, the sad reality is the prosecution of sedition is so routine that we as professionals, as lawyers, as citizens, are not even, are almost numbed to the extent it has been used. This is not a law which is to be applied to your citizens. Well, maybe a class of citizens. And according to me, I believe that the Indian Penal Code has enough provisions to deal with people who may wage war against the state, to people who do armed insurrections against the state. There is law. But speech, I personally think not.
I want to know from you, you are not opposed to the law of sedition or wanting its amendment. You are questioning the wisdom in which the law is enforced by the law enforcement agencies, and why with such ease people have been booked. Is that the case, or are you advocating certain specific amendments to this law?
So let me give you a little historical background. Why did it creep into your law? It was there in the original draft of the Penal Code, as I have written. It therefore comes into it doesn't find its way into the IPC. When there are Wahhabi activities aimed at overthrowing the British, it's brought in 1870 by way of an amendment. And there were some incidents that took place. The Viceroy and a judge of the Calcutta High Court were murdered. So suddenly you get in sedition. Thereafter, it's amended. And throughout its early days, it has been used by a colonial imperial power to curtail free speech of those who wanted freedom. Now, my question to you, sir, is, should this be allowed to be done? Is this legitimate? Is this valid? Is this fair? Is this permissible? And therefore, if we set it up against free speech, my view is Kedarnath Singh did not work. Therefore, it's time for it to go. It's time for Sedition to go.
Justice Sarju Prasad observed that the fundamental right to free speech and expression in the new constitution gave all Indian citizens a right to incite murder and other cognizable offenses with impunity. Then you saw the first amendment to the constitution. We should scrub over what Justice Sarju Prasad said. How would you interpret it?
I think the First Amendment was brought in at a time when we were a young nation. And there was a feeling amongst those then in power that sedition was a necessary tool for the development or creation of a nation state. After all, what were we? We were British India, and we were these disparate princely states which the British controlled. And the idea of the founding fathers was to tie this together into one not just a geographical, but a bound political unit. Therefore, you have ideas, unity in diversity, and so on and so forth. But that was a time when there may have been a necessity to bind the nation together. Today, the abuse of sedition is so consistently apparent that we really need to see how can sedition fit in, and therefore what you said with the reference to Justice Prasad, how can you really fit in sedition in a democratic framework? Of course, if you want to curtail free speech, if you want to curtail citizens' voices, by all means you need provisions like this. And I'll tell you one thing. Today, in an era of the internet, of social media, can you really curtail speech, forget alone free speech?
So I want to ask you, you are in a sense advocating doing away with the law. You're
Absolutely.
not speaking of any amendment.
No.
Okay, I'll now take you back to your article which you authored over a year ago. Queen Empress versus Bal Gangadhar Tilak, where he was booked. Bal Gangadhar Tilak was booked under the sedition law, and the term disaffection was, in a sense, used. Could you please explain this case, A? and also its use in the current legal setup in India when the state is prosecuting people under the sedition law?
So let's go back to that time, because as you know, this issue of sedition and its original avatar in the amendment was very important, because the amendment, as you may recall, used the word disaffection. And what was important was the explanation. The explanation said disapprobation of measures of the government compatible with the disposition to render obedience to lawful authority and to support the lawful authority against unlawful attempts to subvert or resist the authority is not disapprobation. The only thing was inciting or exciting, offenses was what was relevant. Then you have the Bango Basi case, the 1892 case, where articles were saying that there's a threat to the Hindu religion of the age of consent bill. And the judgment lays down the distinction and explains the distinction between disaffection and disapprobation. Then follows Tilak. So Tilak comes later, and that's important. Now, the point was, after Rand and Ayerst, I believe, two eminent British officials are murdered, Tilak gets charged for exciting the feeling of disaffection against the government of India. And that becomes the starting point of an analysis as to what do you mean by disaffection. And the question was hatred, enmity, dislike, hostility, contempt, ill will. And this becomes expanded. And then you have the classic case of Ramachandra, which is again 1898, publisher of a magazine in Sahara district. Because what was it talking about? It was talking about preparations for becoming independent. The author refers to Canada, Canadian citizens' right to self-rule, and draws a parallel to India. Then you have Amba Prasad, again about Azadi. And in these cases, you have different definitions of what you mean by disaffection, and that became the basis and the need for the amendment. Of course, after that, you had this Tilak third trial, Mahatma Gandhi, Annie Besant, Maulana Azad, Sheikh Abdullah. Again, this goes through, as you remember, the interpretative process post the amendment. Post the amendment, you have the Majumdar case, the federal court judgment, and Sadashiv, which is the Privy Council judgment. And there is a gap. So Majumdar case says sedition should be broadly interpreted, but incitement to violence is mandatory. This gets overruled by the Privy Council. No prizes for guessing why. And then you came finally to Kedarnath Singh, which settles the proposition that there must be an element of violence.
If I may ask you, if we have anyone who's making a statement which incites violence, you think there are other provisions in law that should be used? Sedition should be done away with. If these
because, there has to be some violence. I mean, it's like this. Every raver and ranter is not to be given due regard by the law. There has to be an impact or consequence of that.
So you mean every boy with a mobile phone who tweets some random statement can't be booked under sedition? Is that what you're saying? Because social media...
Absolutely right. In fact, I must tell you that if you start doing that, the legal system, the criminal justice system, and defense lawyers would be very busy. And that's not something you want. That is not the hallmark of a good society. I think one of the problems also that arises is that as Indians, and this is my deep-rooted belief, we're very thin-skinned people. We are very sensitive about ourselves. We don't have necessarily the ability to laugh at ourselves or to understand what we're doing right. The inability to accept a fair critique, and that applies across the board. And that is the reason you have a number of these legislations, which in essence have these 19th century laws, and even later, curtailing free speech. So it's not just this. I think there is a larger relook to be had. Once we have ceased to be part of an empire, it has to go.
Mr. Luthra, what would you advocate?
Tarun, I'll tell you, there's a very peculiar thing about the Indian criminal justice system. Till about 1.5, 2 years ago, there was no attempt made to seek to review the criminal law in this country. There have been sporadic attempts. There have been attempts to review the criminal procedure, but there has been no attempt to review the law. So look at 377, homosexual acts. It took us 150 years. And finally, the Supreme Court in the second round did away with it. So my point is, we need to have a complete examination of the myriad criminal laws, and especially provisions such as sedition, at the level of government, at the level of, there's a Committee for Judicial Criminal Law Reform, which is looking at these things right now. And specifically, I would desire as a citizen, as a lawyer, as a student of the law, that this analysis be done. And not only this, the entire IPC be also looked at. A lot of the provisions are good, but we have to change with modern times. Secondly, we never do an efficacy of the law. So we never check, like in sedition, for example, 4 convictions in the last few years. Nothing. Why?
Right.
Why do they fail? So that's a question somebody needs to ask. The point is, prosecution does not translate into conviction. Initiation of and prosecution does not translate into conviction. So what we need to do, and we need to work at very seriously, is we need to ensure that we prosecute. We need to meet the parameters of the offenses, or are we just invoking them casually? Now, the problem which we must deal with in all these issues is, to come back to your original question, we had the Chief Justice of India recently asking in the context of tribunals, we will look into the laws, and it's a question we will need to ask. When we strike down a law, does Parliament really look at our judgment? Is there a debate in Parliament before the law is re-brought in, ordinance after law, regulation, ordinance, statute, in the tribunal's context? So when you have today a polity where you are using the provision of the tool of sedition, I don't even want to call it a provision, the tool of sedition, to prosecute individuals whose voices you do not like necessarily, you think the law is going to get changed? I think not. And if the law is not going to get changed at that level, then my friend, it's up to the courts. But the point is, how much do we keep throwing to the courts? The court's job is to interpret the law, if necessary, to strike down the law. Though today, as you must be aware, in the context of 2 Andhra magazines, in another context, sedition is being looked at even today. The issue of the contours and the applicability of sedition is being looked at by a bench. I believe Justice Chandrachud's bench is looking at it, because I did one of those cases as well. And we may end up having to look at the courts. What is more important, speaking for myself, is that it's time that we started reviewing the criminal law on a 10, 15-year basis. That's not a very short time in the life of the nation in modern society.
So
look at it.
You throw up a very interesting discussion, because when I ask about your law of sedition, you said don't limit it to this. You want a whole review of the IPC. Yeah. You want the whole review of the criminal laws. So you want an all-encompassing eminent individuals committee that could look into it. Now, since you have, in a sense, with your answer, widened the scope of this discussion, may I ask you, this country has had a history of eminent lawyers having important voice in Parliament. That led to very important discussions in Parliament, and of course, laws were passed. So we can agree with the fact that India has no shortage of eminent individuals who have an important voice in the court of law and also the Parliament. Do we lack the political will to implement such a decision where a committee will, in a sense, debate and discuss this law or all these laws? Because the committee will have then to have people from all hues and all points of view.
Don't leave it to practitioners of the law. We are merely dissectors of the law, analysts of the law, and we only believe in representing individuals. Some of us who are in parliament, some eminent voices are those who are deep thinkers, but they will have their limitations. These exercises have to be driven by academia, supported by government, and then brought into legislatures. One of the biggest failings of our legal education system is that we no longer have adequate academic voices raising the problems with our laws. We have not created a cadre of academics. There are some good people. I must tell you, there are some very, very good people who come up in the last few decades. But the ability of academics to tear up a legislation or a precedent, a judgment, has slowly and surely been lost.
So you mean there are no public intellectuals in the field of academia whose voice is respected overall or is even sought?
It's the way your education system is, because the dependency, even in the national law schools, on court support, even in the term of appointment, restricts the freedom of intellectuals to speak up or their desire to speak up. And it's important that we free, just as we have independence in the judiciary, we also free up our educational institutions from all control to make them independent and make them strong enough for critiques both of the functioning of the entire criminal justice system, from policing till prisons. We need a reality check. You see, you have to realize one thing, Tarun, and this troubles me a lot. The reach of the criminal law in the last 5 decades has become so expansive that there is rarely, when you wake up in the morning and when you leave your home, you are coming in touch with the criminal law at various points of time. You may offend, you may not offend. If you speed, if you cut a red light, if you use a mobile phone while driving, and some of us are great offenders.
But I'll now take you back to your article. You quote K.M. Munshi and say, 150 years ago in England, holding a meeting or conducting a procession was considered sedition. Even holding an opinion against, which will bring ill will towards the government, was considered sedition. Our notorious section 124A of the Indian Penal Code was sometimes construed so widely that I remembered in a case a criticism of the district magistrate was urged to be covered under the sedition law. But the public opinion has changed considerably since then. And now that we have a democratic government, a line must be drawn between the criticism of the government, which should be welcome, and incitement which would undermine the security or order on which civilized life is based, on which is calculated to overthrow the state. Therefore, the word sedition has been omitted. Now, may I ask you, in the UK, you have a 2-year sentence if you're convicted of seditions. So it's not life sentence. Plus, the arrest is not at the whims and the fancies of the law enforcement agency. Now, there is this term that, you first, in a sense, catch what you can do early. So are these implementable things that, okay, we can't do away with the law, but do we need a life sentence? We can't do away with the law, but do you need a court's order to get someone arrested under the sedition law, or just the agency can go and pick anybody up? Do you think these are achievable things?
Again, this will require the legislative will. And if there is a legislative will to relook at sedition, then anything can be achieved. After all, don't forget, the gentleman under whose watch sedition, the constitutional amendment came, which brought in sedition in Article 19.2, says in Parliament, and he says this, and that's Pandit Nehru, who says, I'm concerned that the particular section is highly objectionable and obnoxious and should have no place both for practical and historical reasons, if you like, in any bodies of law that we may pass. The sooner we get rid of it, the better. And yet, under his watch, the amendment came into the Constitution. So understand this. Realpolitik is vastly distinct from an idealistic society. And the reality of any democracy is that the majority which forms government is the one that, unless you have a very effective and strong opposition, will pass the laws that they desire.
Okay.
Therefore, there has to be a legislative will. The courts also, in Common Cause and others, have chosen not to interfere, not to go beyond. In fact, even recently when this issue has come up, the court said, look, let's add certain more parameters to Kedarnath Singh. But my point is, a tinkering by the courts will achieve limited results. It is a case of either it should remain or it should not remain. You are absolutely right. There can be permission sought before registering an FIR. There can be other issues. But remember, investigation agencies have ways and means to get around it. All they need to do is, the nature of the offense being such, they will always add cognizable offenses to be able to invoke it. So the point today is, look at the gamut of offenses in the penal code for violence against the Indian state. Look at the UAPA, Unlawful Activities Act. All these offenses exist. Why do we need this?
Thank you so much for sharing all these views. We started on the law of sedition, but expanded the scope of the discussion to include other criminal laws and also the IPC review. We hope the viewers enjoyed the deliberations today. I would like to thank Senior Advocate Siddharth Luthra for, in a sense, allotting us time for this discussion and sharing his views with us. Thank you, viewers, for joining us. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.